Now, we've all encountered and we've read about cases where people have been treated very unfairly or where courts have come up with bizarre outcomes. So you all remember the McDonald's case, right? With the hot coffee, the woman who got burned by hot coffee. Wow, now we all have little notes on the Starbucks and Pete's, this could burn you. We didn't know that before, right? And it resulted in a multi-million-dollar settlement, that case. My favorite unexpected case and bizarre case had to do when I was just finishing up my law degree in the Philadelphia area. And Philadelphia is well known as a plaintiff's town. A plaintiff's town means that if you make a claim, no matter how absurd, a jury of 12 people in Philadelphia will say, sure, here's money. Okay, that's a plaintiff's town. And sure enough, this woman was involved in a truck and car accident. She was driving the car. Truck hit her. Apparently, the truck had been doing something, really crazy in terms of driving, and so she sued. And she claimed, among other things, that she had lost her psychic powers as a result of the accident. And true to form, the Philadelphia jury found against the trucking company to the tune of something like $12 million or $11 million. Now, interestingly enough, in that case, the appellate court, called the Commonwealth Court in Pennsylvania, took the appeal. And they said, in one way or another, they kind of edged towards it. But among other things, they said, that kind of damage is not foreseeable. You're not responsible for that kind of unforeseeable damage. And I'm sure that the panel was having a great time saying, well, if she was psychic, why didn't she avoid the accident to begin with? So there are sometimes that the courts seem to be very illogical, and we think this doesn't make much sense. But the cases that we rarely see, that kind of are the daily thousands of cases that go before the courts in the United States, involve this idea of foreseeability. And many of us are protected by that idea, because if it was foreseeable and we followed the standard of care for a particular event, even if bad things happen, even if risks materialize, we are not held responsible. So a client who says to us, I'm fine, when we do an evaluation, and they deny any suicidal ideation, they say, I'm coming in because of some mild anxiety, and you do a reasonable assessment in the intake, you set up an appointment, you note down in your records, anxiety issues, no danger to self or danger to others denied, and 2 days later that person kills themselves. It's tragic, but you and I will not be held responsible for it. Why? Because the standard of care says we must ask the question, but we're not required to predict the future with absolute certainty. And we have to rely on what our clients tell us. And although probably most of you have had some experience with this, I have some bad news for you. Our clients lie a lot. In fact, the literature on therapy suggests that they're often engaged in a tremendous amount of impression management with therapists and would like us to reflect back a good person. And so they omit lots of things like, I've just beaten my child, or I'm involved in a domestic violence relationship and I'm the one who's precipitating the violence. Okay? Still, in the context of foreseeability, we're required to ask the questions and do a reasonable assessment. We are not required to be perfect. Okay? So this idea of types of risks, we're not typically held responsible for unforeseeable risks, but when they're foreseeable, we follow the standard of care. Now this does raise a question, doesn't it? How does one determine the standard of care in a particular instance? And also, what happens if there is none? Although it's, I'd say at this point, less an emerging technology than just a reality that we've had for years, there's still quite a bit of debate about doing therapy on the web. What are the standards for doing therapy on the web? And can it be done in an appropriate fashion? All right? Where it's not clear, what one does, among other things, is consult with colleagues and do what seems prudent in the circumstance. But in those kind of adventuresome avenues, there are greater risks. Why? Because we really haven't yet established standards of care. And so if some harm occurs to a person as a result, then the argument can be, well, you didn't do what you should have done. And at that point, they may be right, because what was happening was, well, I didn't foresee it, even though it's not unreasonable to think that it could happen, because it's a new environment. Right? So newer environments tend to be risky, and that doesn't mean that one shouldn't do that kind of work. We just do it with some care. And we want to talk to other people about it. Okay? So two different kinds of risks, important to keep in mind. Right? Now, there are different, actually I realized I've skipped over something. Risk does not just involve, of course, risk to us. When I'm talking about risk, I'm talking about risk of harm to clients primarily, the people we're working with, and acknowledging that that harm cannot be avoided at times, but there's a risk of harm to them. We're also, though, included in the equation. So what's the risk of being sued or harming someone and then also being harmed ourselves? If the statistics are even close to accurate, over a quarter, actually over a third of mental health professionals are assaulted during the course of their careers by clients. Okay? And if there's some time permits, I'll talk a little bit about steps to take to reduce the likelihood of harm to us and also the likelihood of assault. Happens mostly in inpatient units, but it does happen in outpatient settings as well. Okay? And there's also property damage that clinicians sustain, not too infrequently, unfortunately. So we get to include ourselves in this equation. Risk is to clients, risk is to us, and there's also risk to the community. That's why courts have decided that we do a tariff-off, because that kind of risk is something that is foreseeable, arguably. I think it's still very arguable, and something that arguably we could prevent by warning. It's an interesting issue because there's very little evidence that warning reduces the likelihood of harm. And my belief is that in domestic violence cases and also in gang-related warnings, it increases the likelihood of harm. So there's not a lot of empirical evidence to suggest, from my perspective, that tariff-off works, but it's a fairly well-accepted rule. So some environments, with these kinds of these global ideas of risk, some environments pose to us greater risks than others, pose to our clients greater risks than others. Some types of services create greater risks. They tend to be services that make determinations about whether people receive resources or not. So, or access and whether they get their rights and what they believe to be their rights or not. So child custody evaluations, a classic example of a riskier kind of assessment and also work. And it's not at all uncommon for people to have licensing complaints against them when they're doing child custody evaluations, because it's one of the few avenues open to people who are unhappy with the results. Unfortunately, anybody here do child custody evaluations? You do? Okay. We have a couple of brave souls in the room. Not anymore, okay. A wise soul and a brave soul. One of the things that courts have been allowing more recently, which is rather disturbing, is those of you who've done or you've been around people who do child custody evaluations know that almost always you get what's called a 730 letter or a court order in order to do the evaluation. And that protects you from civil or criminal liability. You're just like the judge. You make recommendations to the judge, somebody sues you, it bounces off you. You're immune from liability. Some courts have been at the behest of one of the parties piercing the immunity when there's an allegation of unethical conduct, which means the immunity is worthless. And it's going to reduce, I mean, good people continue to leave and, you know, brave people hang in for a while, but it takes a lot of fortitude to withstand, and also, not to mention money, to withstand these kinds of accusations and continue to do that kind of work. So it's riskier, but it's not only risky to us, it's risky to the clients. When you think about it, the children are at high risk because if our decisions and recommendations are wrong, it changes their whole developmental trajectory. The parents are at risk in part because they could lose rights that they should have. So there are some very weighty kinds of decisions being made. But Social Security and SSDI decisions, people lose access to very crucial resources, greater risk situation. Okay? If you work in a forensic setting where you're making recommendations to a board of prison terms, boards of prison terms make decisions about paroling people, okay? Well, sometimes folks get mad when we say they shouldn't be released. And then when they do, we could be at greater risk, but so could they if we make an erroneous recommendation, okay? So environment does play, and the type of service plays a significant role in the type of risk or the amount of risk that we would experience. However, if we average the risks that we encounter as mental health professionals, for the most part, we are not in really a very risky business. Physicians can be expected to be sued about once every 6 years. That's an average physician. If you're in the Kaiser system, that means somebody will go after you in arbitration once every 6 years. That's every practitioner. That's why they're spending anywhere from $40,000 to $100,000 a year for malpractice insurance. If you're an OBGYN or you're a neurosurgeon, your malpractice insurance is much higher and your likelihood of being sued is much more frequent. Okay. If you're a typical non-medical mental health provider, compare the rates of lawsuits, just as a very rough estimate of risk. There's nowhere near as many lawsuits as there are harms or injuries done. Okay, so it's a very rough estimate. 1 in 19 of us, over the course of all 19 folks' careers, can expect to be sued. So in a group this large, we're probably talking about 2 to 3 people being sued in all of our collective careers. Very low rates. Even if we think about licensing complaints, which are much more frequent because one doesn't need an attorney to say, oh, there's likely to be good money in this one, right? It's 1 in 9. So only about 4 to 5 of us in this room would have a licensing complaint against us in all of our collective careers. So if you just use that as a marker, we are not in a very high-risk profession, okay? Now, that doesn't mean we can simply relax and say, oh, don't have to care about anything, but it's toward getting us off of being really panicked that, uh-oh, with this legal stuff going on, we're in big trouble. Because generally not. And the types of things, if you take a look at California Therapist in any given month or two, those of you who've read the California Therapist, it's the Kampf publication, and they have the 3- and 4-page descriptions of what colleagues have done wrong, right? And the actions by the various boards. That is a fairly infrequent event.